Hi, I'm Emily, and I am here with Maya Murphy's attorney, Eva Marie Franco Fox. Attorney Fox practices at Maya Murphy's Westport, Connecticut office and is admitted to practice law in both Connecticut and New York. My question today for Attorney Fox is, what issues can be included or addressed in a Connecticut prenuptial agreement?
There are actually a number of different issues that parties in Connecticut can include in their prenuptial or postnuptial agreement. In fact, the Connecticut Prenuptial or Premarital Agreement Act includes a specific list of items that can be addressed within the agreement. So, for example, the rights and obligations of the parties to any property, their estates' rights, their rights to any alimony or the elimination or modification of alimony, and even their personal rights and obligations. So, as you can see, this statute, this law, is very comprehensive. It includes a number of different issues that can be addressed, and so it gives the parties great discretion or latitude in determining what provisions they want to include based on what meets their specific needs and concerns, and that may vary from couple to couple. Certainly, there are certain issues that we see pop up in prenuptial and postnuptial agreements very often, and they really should be addressed within the agreements. They're kind of the basic terms that you would want addressed in your agreement. And those terms relate to the assets and liabilities of the parties and the income and expenses of the parties, as well as any provision that would speak to alimony or spousal support and estates rights. What can the agreement say about these specific issues? Well, they can align with Connecticut law, meaning they can comply with what the state law would generally allow in the event of a death of the spouse or a divorce, or they can deviate from what the state law would generally dictate. So the parties may look at the laws of the state and say, if we were to get divorced, what the law is dictating isn't really appropriate for our situation. It's not what we intend. It's not how we would want our assets or our debts or our income to be treated. And therefore, we're going to contract around these laws. We're going to create an agreement that's really customized to our specific needs and our concerns and what works best for us as a partnership. Now, I do want to just make a quick distinction here. Deviating from the law is not the same thing as violating the law. So these agreements can deviate from the law, and they can kind of really customize the terms in a way that's better fit for the parties, but they can't violate the law. They can't violate public policy. They can't include any terms that would be considered unconscionable or morally reprehensible under Connecticut law. I've actually done a whole video on what provisions cannot be included in these agreements, and I encourage you to look at that if you're in the negotiation or drafting process in order to fully understand how to structure your agreement. We'll link it down below. But just so you know, there are provisions that can't be included. Otherwise, the parties have great discretion to really address their financial and property rights as they see fit. So, other than either aligning or deviating from the law, what else can the agreement say about these specific categories? I'll address each category here briefly, but I will also do separate videos on each category because they each really do warrant their own full discussions. There's a number of different issues that can be addressed within each category, and it's important for the parties to really get a comprehensive view of all the different ways that these issues should be addressed within the agreement. It's not very black and white. So, assets, for example. How can the agreement address assets? As I said, I'll do a full video on this, but briefly, the agreement can and should break down the assets and kind of distinguish between premarital assets and assets acquired during the course of the marriage. Now, it doesn't need to treat premarital assets and assets acquired during the course of the marriage differently, but it should acknowledge that there are these two different kinds of assets. Premarital assets are generally assets that the parties own prior to the date of marriage. They come into the marriage with them. And assets acquired during the course of the marriage are just that. They're assets that are acquired after the date of marriage. As I said, these assets can be treated the same or they can be treated differently, but they should both be acknowledged, disclosed, and addressed. So, for example, it's very common for parties to say that premarital assets will be considered separate property. Separate property is generally thought of as the property of only one of the spouses, and it's not subject to any kind of division in the event of a divorce. Parties often will say that assets acquired during the course of the marriage are considered joint property. Joint property is considered to be property of both spouses and is generally subject to division and to some degree or to some level within the context of a divorce. So, it's not just as simple as identifying separate property or joint property. The parties really need to get even more specific than that. There may be circumstances where separate property is commingled, and does that convert it to joint property or does it remain separate? So, for example, The parties may have premarital assets treated as separate property in their agreement. But what if they sell that separate property and then the proceeds, for example, the sale of a house, the sale proceeds are then put into a joint account? Does that convert it to joint property? Or is that party still entitled to pull those assets out in the event of a divorce because they're still considered separate property? Or alternatively, what if a party uses the separate assets as a down payment for the acquisition of a joint asset? Does it then convert those separate assets to joint property? Or is the party still entitled to, again, pull that property out in the event of a sale of the joint property? So are they entitled to any kind of reimbursement for the down payment that they contributed, or is it converted? When they sell it, are they going to split those proceeds 50-50? Are they going to split them in proportion to how they invested in the property? So even within joint property, as you can see, it's important for the parties to clarify how is property going to be distinguished or characterized as joint property. Is it any property that's acquired during the course of the marriage, or is it going to be only property that they put in joint name? Is it going to be only property that they both contribute to financially? So they need to contribute to it equally financially. So these are all issues that really can and should be addressed within the agreement. By addressing them, you can prevent any future disputes, uncertainties, confusion down the line. The goal of these agreements is really to prevent litigation. It's to set the parties up so that they understand what their rights and obligations are, and in the event of a death or a divorce, they know how to proceed and with as little dispute as possible. And so by leaving these issues out, by leaving your agreements silent on a number of these issues, it leaves the parties open to confusion and disputes down the line where they don't know, for example, how the appreciation of a separate property asset is going to be treated, who owns it, who has rights to it. And they may be stuck litigating over this years down the line when it very simply could have been addressed in one or two sentences within their agreement and really save themselves the heartache and the headache of fighting about it years later. Divorce is stressful enough. You don't need to add additional stress to it by fighting over something that could have very easily been addressed in a proper agreement. Other issues that are commonly included in these agreements are income. How are the parties going to treat income? Is it going to be separate property? Is it going to be joint property? In addition to that, the parties really should address how they are going to address different types or sources of income. So a party may be an employee and have W-2 income, but they may have different forms of income from that place of employment, for example, bonuses. They may also have income from other sources, investment income, rental income. All the different sources of income should be disclosed and they should be addressed within the agreement. And another topic, expenses and liabilities. Again, the parties really should distinguish how they're going to treat their premarital debts and their debts that are incurred during the course of the marriage. And again, they should address things like what constitutes a joint debt. Does it have to be in joint name? Is it something that is applied to a joint purpose? Is it something that they both need to consent to? Is it under a certain amount? The parties really need to contemplate all these future circumstances, these scenarios, and address them in the agreement in order to have a really comprehensive agreement and avoid disputes down the line. Again, this is the goal of these agreements, to really settle issues and resolve issues to the extent that they can be resolved proactively. Again, another common provision is alimony or spousal support. The agreement can address whether or not either party will be eligible or entitled to it. If so, what the amount will be, how will it be calculated, not only how much it will be, but what will the duration or the term be. Is it going to be one lump sum? Is it going to be paid for 1 year, 5 years, 10 years? Is it lifetime alimony? What are the circumstances that would make a party eligible for it? Do they have to have below a certain amount of income? Do they need to be married for a certain period of time? All of these issues can be treated or addressed within the agreement. And certainly if there's going to be a waiver, that should be explicitly stated within the agreement as well. Estates' rights can also be addressed within the agreement. The parties can address whether or not they're going to waive their right to elect into one another's estates, particularly if they've been disinherited. Are they going to modify perhaps what the minimum amount is or the maximum amount is for the elective share rights? And also legal fees. The parties can address how they will treat legal fees in the event of a dissolution of marriage. Are they both going to pay their own fees? Is one party going to pay all the fees? Will they use joint assets? Again, these are all issues that can and should be addressed in a comprehensive agreement. And these issues, as I said, are not straightforward. They're not black and white. We may have a circumstance where it looks like, oh, very easy. You can just say, we'll treat premarital assets as separate property and joint assets, assets acquired during the course of the marriage as joint assets, and go on our way. It's not that easy. There are a number of different issues that within those distinctions also need to be addressed in order to really have a comprehensive and complete and proper agreement and avoid litigation. So we encourage you, if you're in the negotiation and drafting process, contact our office or contact your local attorney and really get advice on how to properly address these provisions, because it's so important in order to avoid future disputes.
Attorney Fox is available 24/7 and can be reached by calling 203-221-3100. You can also email Attorney Fox at efox@mayalaw.com, and please visit mayalaw.com for more information.